Further hearing in the appeals ABC against principal reporter and another and in the matter of XY.
Yes, Mrs. Scott.
Ladies, my lords, I have just an hour and I have endeavoured to discipline myself to just 4 points. And my headings in brief are 1, the questions, 2, the test, 3, fair hearing, and 4, proportionality. And I propose to try and whistle through the first 3 to enable some focus on the 4th. So first of all, the questions. The appeal in the case of XY is a stated case appeal. And the questions to be answered, the court will find in the Statement of Facts and Issues at Memory Stick 81. These are 2 of the questions remitted by the learned sheriff to the Inner House, and the only 2 questions that the Inner House was asked to answer. And the logically first question is question 8. Should the decision as to whether the applicant is to be treated as a relevant person be returned to the Children's Hearing for a fresh determination on the basis of an interpretation of the 2011 Act that is incompatible with Articles 6 and 8 of the European Convention on Human Rights? And I invite the court to answer that question in the affirmative, and that is to allow the appeal against the Court of Session's decision, which answered in the negative, and that is the interlocutor on page MS 199. Question 6 is logically the fallback position, and that is the incompatibility issue. That question is there because it carried the possibility of the appeal to this court if the answer to the other question was in the negative. And the way that this court answers that question depends on its answer to question 8 and, of course, on my learned friend Miss Brabander's submissions. But if this court is minded to answer question 6 in the affirmative, there will be no point in a remit because the problem cannot be cured without legislation.
Well, you basically say that there is a problem and Section 3 is the answer to it.
I do.
Whereas in ABC, there is a problem and Section 3 isn't an answer.
Yes. My fallback position is if there's no answer, then we go to...
Yes. You would obviously take the same view
yes.
as Ms. Ravenel if...
We're in the hands of the court.
Yeah.
So if I can move now to the test for relevant purpose status. And the difficulty with this test is, as it has been interpreted in this case, and indeed in other cases, it excludes from involvement as relevant persons individuals who apply for that status, such as siblings who, and I'm going to quote here from Lady Hale in Principal Reporter against Kay, quote, who appear to have established family life with the child with which the decision of the hearing may interfere. What we have in section 81.3 and the equivalent sections which have the test of significant involvement in upbringing is narrower than the test formulated by this court when it previously addressed this issue. Now, I'm going to take the court briefly to the legislation, as it's the legislation I'm attacking. Would the court prefer that I refer to memory sticks in the XY case or the ABC case? I can do either.
I've got XY on my screen at the moment.
Very well. Then I'm going to refer the court to tab 2 in XY and to semi-stick page 299.
299.
299. And in particular to section 79, subsection 2, the principal reporter, A, must refer the matter of whether a particular individual should be deemed to be a relevant person in relation to the child for determination by essentially the pre-hearing panel if requested to do so by the individual in question. And of course, XY made that request to the reporter. The pre-hearing panel is then required to act under section 81, which is on MS page 302. This section applies where a matter mentioned in section 79.2a, a relevant person claim, is referred to a meeting of the pre-hearing panel. And there's a duty to determine that before determining other matters. And 3, the pre-hearing panel must deem the individual to be a relevant person if it considers the individual has or has recently had a significant involvement in the upbringing of the child. Now, what I'm seeking to have read into that is or appears to have established family life with which children's hearing may interfere.
I must say, Mrs. Scott, when I read that, I said to myself, well, the pre-hearing panel must deem in those circumstances, but is it clear that it may not deem in others? And so I got rather excited about that, a possible way of resolving matters, until I turned to section 81A3, which of course was inserted later.
Yes.
Which puts the kibosh on that.
So it does.
Because the pre-hearing panel must determine the individual is no longer to be deemed if he hasn't had the significant involvement.
Yes, quite so. Yes. So one has to be a relevant person. I'll
Yes.
come on to why it's relevant person or unfair hearing. Now, the decision of the Sheriff Appeal Court in the XY case is in the core volume, and I'm going to refer to part of that decision starting on page 231.
Sorry, could you repeat the page number?
231.
Thank you.
What the learned sheriff has done in the XY case is to say, in the course of a different process, I have given XY interim rights to contact. He can't defend that unless he's in the panel, in the children's hearing, and therefore he ought to be a relevant person. And what the Sheriff Appeal Court has done has reversed that decision. And what they say at the middle of the page in paragraph 9, Section 81.3 of the 2011 Act provides that the pre-hearing panel must deem the individual to be a relevant person if it considers the individual has or recently had a significant involvement in the upbringing of the child. Thus, the issue of significant involvement is a question of fact. The Sheriff does not address that issue directly. It's plain his real concern was the effect of DM not being a relevant person, that's XY not being a relevant person at the children's hearing, when the question of continuing contact between him and LM would be a live issue. For the purpose of Section 81.3, that is an irrelevant consideration. And then jumping to the following page, in paragraph 10, we accept that the exercise of an award of contact, however limited, even to the extent only of telephone contact, which we were told has already also occurred, and the opposition to the permanence order application are relevant circumstances, which the panel was entitled to take into account. Indeed, before us, the locality reporter did not maintain they were irrelevant, but of themselves they cannot lead to the conclusion of significant involvement in the upbringing of LM. Here, factors such as those set out in the guidance issued to panel members by the National Convener of Children's Hearing Scotland, as quoted by the Inner House in MT against Gerry, are absent. So this is the Sheriff Appeal Court's take on the test. And it's an important take because it binds every sheriff in Scotland. And that's the result of the Court Reform Scotland Act 2014, Section 48. It's at tab 25. I'm not going to turn to it. And it's a factual test, a straightforward factual test, as the Sheriff Appeal Court has it. And they derive that test from the Gerry case at tab 12 in the authorities. And this is the first time that the Inner House had dealt with it. And if I might take it very short, given the difficulty of timing.
Page?
I'm going to start at page MS 620.
Thank you.
Paragraphs 11 and 12, the Inner House confirm that this is a factual test. Section 25 and the welfare test does not apply to that factual test. And then the key to it is perhaps in paragraph 17, about 8 or 9 lines down, where the court says, a significant involvement in the upbringing of the child, as opposed to a significant involvement in the child's day-to-day care, was what the test required. And they go on to quote from the guidance mentioned later by the Sheriff Appeal Court, which is at the foot of the page, and in particular 4.4. The test is of significant involvement in the upbringing of the child, rather than any particular care of or contact with the child. The Oxford English Dictionary definition of upbringing is the treatment and instruction received by a child from its parents throughout its childhood. Other considerations, such as the best interest of the child or the character of the individual, are not relevant considerations for being deemed a relevant person. So that is the test which every sheriff now must look at by virtue of the Sheriff Appeal Court's decision. Now, it's clear that there has been some discomfort with that test, and that perhaps is what I derive from the Inner House's later decision in CF against MF at tab 7. But basically, in CF against MF, the Inner House adhered to the Gerry test. And I don't think time permits me to go through an analysis of CF against MF. The Inner House has been asked to look at whether the test might be more flexibly interpreted, and was invited to do so by Malherbe Jr. when he appeared in the case of DM against the locality reporter at tab 9. And again, time doesn't permit to look at that in more detail, but there was a submission that this should be looked at again. The court did not consider the interpretation. In the XY appeal in the Inner House, the court was again asked to reconsider interpretation, and the court will have seen from the decision in this case that opportunity was again declined. And the submission on behalf of XY is that if the binding interpretation, or currently binding, subject to the decision of this court, interpretation of the Sheriff Appeal Court is correct, we have a test for involvement as a relevant person, which is a factual test based upon significant involvement in upbringing, and that is incompatible with Article 8 because it leaves out persons who appear to have family life with which the decision of the hearing may interfere. There is a helpful question put by counsel for the fifth respondent, AM, at paragraph 39 of that case. And the question is whether properly construed in accordance with Section 3 of the Human Rights Act, Section 81.3 of the 2011 Act enables a non-parental family member such as XY who does not fulfill a parental or quasi-parental role to be deemed a relevant person. And if that question is in paragraph 39 of the case, if that question is asked in the affirmative, that solves the problem. That's my second heading, in brief. So my third point concerns a fair hearing, because I am in complete agreement with Ms. Brabender that if a sibling is not deemed to be a relevant person, he or she will not have effective involvement in the decision-making process in respect of the child who is the subject of the compulsory supervision order. I agree with Ms. Bramber's 6 minimum requirements for a fair hearing. And I have 2 footnotes. And they're both about the practical operation of the children's hearing. And I should explain, I have the benefit of a learned junior who was a reporter. So I hope I'm well informed. The first of the footnotes is this, and it's a difficulty which might be difficult to appreciate from this distance when there's no equivalent to a children's hearing in this jurisdiction. But a children's hearing is a lay panel. These are not lawyers, and they're not schooled in procedural fairness. That panel or hearing may have a different membership on each occasion that it sits. There is no necessary continuity from one children's hearing to another. And the point is made in the case for XY that the chairman of that hearing will not be selected until minutes before the hearing. And it's a rotated position, so if there are 3 hearings in a morning, a different panel member may chair each of those 3 hearings. So to answer a point put by my Lord Wilson yesterday, you don't have a chairman who is considering these issues at an earlier stage because it's much more ad hoc in its organisation than would admit of that.
You can continue.
Yes, but you won't necessarily have the same panel. Yes. So the panel might not know why you've continued. They'll simply meet again.
There won't be a written reason for
There are written
the
reasons,
continuation.
short written reasons in layman's language as to the reasons for a decision, a deferment of the hearing. Yes, there would be. So it would be outlined.
Very well.
On the other hand, delay is always inimical to the interests of children.
Indeed.
And is to be avoided where possible. But
one magnificent feature of this legislation is the speed of the whole thing.
one might think so. It can. Sometimes it doesn't. It all depends.
Yes.
But one magnificent feature of it, one genius of it, is, of course, the way that decisions are taken are by discussion. Matters are discussed at the hearing. And that's why it's so important to be able to take a proper part in that discussion.
So there's no witness box,
No evidence.
no evidence, no cross-examination.
Nothing.
Thank you.
There is simply a table with 3 panel members, the various persons arrayed around, and a discussion.
Yes. I mean, I have observed children's hearings.
Yes.
I know how they operate. It bears no resemblance to anything that could be called a trial in a court of law.
Correct. Which is why one has to set aside any preconceptions. And why, in the submission of both appellants in this case, relevant person status is so important. And also why the sheriff, which is a court of law, plays a vital part in the system. Because the sheriff will hear evidence when the need arises, particularly if there's a dispute over grounds of referral, and potentially on appeal. But also the sheriff can correct errors, and they do happen. And so the backstop, as we had it yesterday, is integral and essential to the hearing. And it's perhaps of note that this, in Michael, the Strasbourg court noted that it was necessary to have procedural fairness to allow the parents in that case to know whether to appeal. So if a sibling, such as ABC or XY, is not deemed to be a relevant person, that sibling won't have basic procedural fairness. That's the first footnote. The second footnote is this. It is not possible to make an application to a children's hearing for contact, or anything else for that matter, to be considered. There is no procedure for it. All that somebody in ABC or XY's position can do, particularly XY, is ask to be deemed a relevant person. If you find out there's a hearing, you might not know. And the Scottish Children's Hearing is in that respect very much in the position that England and Wales found themselves in in W against the UK. And the reason why there was a friendly settlement and a payment made to Mr. Boyle in the Boyle case. And the structure of a hearing is also inimical to application, because there is a set procedure for children's hearings. The focus is on, is this compulsory supervision order still necessary? Should it be terminated? Should it be varied? And that is a position which is set out in section 138 of the 2011 Act. That always comes first in every hearing. And then if the CSO is to continue, what overall form should it take? And at that point, it is possible in the context of the discussion to consider contact directions. So one doesn't have a bespoke hearing. One looks at the round. And at that point, the question raised yesterday by Lady Hale becomes pertinent. There is no express requirement for any report on sibling relationships. There is no guidance to the local authority in its extensive reporting under GERFEC to provide anything about sibling relationships. I note that the court now has a very helpful note from my learned friend Miss Brabender in the ABC case. In it, she refers to the Looked After Children Scotland regulations. Now, what they do is they require the local authority to prepare a child's plan. That plan is governed by Schedule 2, paragraph 7 of those regulations, which I don't think the court has been provided with. And when you come to Schedule 2, paragraph 7, that deals with contact, but it's contact with the persons who are mentioned in section 17.3 of the Children's Scotland Act. And if one goes round that paper chase, as far as section 17.3, there's no mention of siblings. In the Safeguarders bundle, there is the practice standard for safeguarders. The practice standards for safeguarders do not mention siblings. Safeguarders are to some extent constrained by a very limited feeing arrangement, which no doubt Mr. Setright will be able to explain. They don't have a lot of scope to do a great many investigations.
In what proportion of these cases is a safeguarder appointed, roughly?
I would be guessing.
Of course you're guessing. Half?
I don't think half. No, nothing close to half.
No. Do they have to have a social work qualification?
No. There's been a recent reorganisation of safeguarders under the aegis of Children First.
Who would normally be appointed a safeguarder?
There are some solicitor safeguarders, there are some social work safeguarders, there are a few with broader qualifications with children, but it's mainly solicitors or social workers.
So it would be solicitors and social workers who have experience in this field.
Also police officers, my junior advisors.
I see. Thank you very much.
Retired police officers. Retired police officers. Mental health workers, possibly. My learned junior and I searched last night for any guidance to the children's hearing to consider sibling relationships and found none, other than the relevant person guidance, which refers back to the test in 81.3. Now, all that means, if one wishes to ensure that the sibling relationship is dealt with in a fair manner, the sibling needs to be at the hearing. And the problem that is identified for XY with the first and the second respondent's position is it says that the sibling relationship cannot of itself merit a fair hearing. And of course, the only attempt at a bespoke hearing is Section 126, and I adopt Ms. Brabenner's analysis of why Section 126 is a wholly ineffective piece of legislation. I just add, from XY's perspective, the reason why XY sought to be involved in his sister's children's hearings, and this is mentioned in my case at paragraph 12, is he had broader concerns. He had concerns about the foster home in which the children were living, and about confidences reported to him by AM and EM, and I shall leave that to Mr. Richardson's case. He also had concerns about the local authorities' attempts to remove them permanently through a permanence order, and the attempt to suggest that when they refused to be removed permanently, this was because they had some sort of incapacity, which meant that their consent was not required. So there was a whole broad sweep of concerns which XY had, in relation to which he sought involvement as a relevant person. Now that takes me to proportionality. My proposition is this. I say the burden falls on the first and second respondents to establish that failure to afford procedural fairness to siblings is justified and proportionate. That is, first, there is a sufficiently important objective to that exclusion. Second, that the interference is rationally connected to that objective. Third, nothing less intrusive could accomplish that objective. And then fourth, that a fair balance has been struck between the rights and interests of the different persons involved. And I see Lady Hale
We know
smiling.
where you're getting all of that from.
I know you do. I thought you might recognise it.
We've heard
Well, it
quite
began with
often.
my lord.
So I acknowledge. It's directly from paragraph 78 of my Lord's decision in the Carey and Bindloss case. But of course, I note that Lady Hale and Lord Hodge were also involved and concurred. So I'm
It's cited to us all the time, Mrs.
Well, it's
Scott.
the
I'm sure it is.
You can call it the four-step test if you want.
Yes, I'm grateful. Well, I respectfully adopt it, and I'm assuming that this is something that the court will be minded to follow. But if we take it from there on the standard application of Article 8, we'll look to see, first of all, is Article 8 engaged? And of course, the existence of family life is a question of fact. We know that from the BINC, that's cited in Principal Report against Kay. So that is the preliminary question of fact to be addressed.
I don't think the engagement is disputed, is it?
I don't think it is, but it's the first step.
Yeah.
But then the second step, and again, I don't think this is disputed, family life is being interfered with by the decision of the children's hearing. Third, that exclusion be in accordance with the law. You can't be arbitrarily excluded, and I've got something to say on that in a moment. And then there must be relevant and sufficient reasons for limiting involvement in the decision-making. The limitations must be justified and proportionate. And what I say about the first and second respondents' position is they're looking down the wrong end of the telescope. Because if siblings do have an established family life with which the decision of the children's hearings may interfere, it's for them to justify a system that fails to involve those siblings in the decision-making. And I have 3 complaints. My first complaint is this. It involves the element of arbitrariness in the proposed solution, which is based upon an invitation under Section 78 of the 2011 Act. Now, I've taken my definition of what is arbitrary from the standard authorities cited in Christian Institute against the Lord Advocate at tab 8. And I'm not going to go to it. I'm assuming that those are familiar standards. But what I say about the difficulty over section 78 is there's a lack of clarity for a person such as XY about whether they'll be admitted. And there is insufficient foreseeability to enable such a person to order their affairs. If one looks at the invitation letters which are issued or now issued, because this is a process which has sprung up since these cases have commenced, there is an invitation letter at MS 249.
249. 249, thank you.
This just happens to be the AM letter. There's an equivalent one for LM and EM. And this was addressed to XY. I'm telling you about the hearing. There's a date and time, because you might want to attend in relation to your contact with the child. Well, that's not the only reason I want to attend, but let's set that aside. If you attend, the chair of the hearing will decide on the day whether to allow you to come into the hearing, and if so, how long you may stay in the hearing. So, the recipient of one of these letters won't know in the advance whether they're going to be able to take part or whether they're going to be admitted. And if one takes, just for example, this case, the children's hearing is in quite a remote location. A family member could rearrange their life, book their travel, present themselves, and be turned away. And being turned away is difficult for a 23-year-old, such as XY, but then one puts oneself in the position of a younger person, such as ABC, who has summoned the courage to go because they want to be involved and is told to go away. And of course, the reporter cannot say whether or not the person invited will actually be admitted to the hearing, because that decision lies in the hands of the chairman. And of course, that chairman may not be identified until minutes before the hearing. There's no decision in advance. Someone gets into the whole problem of the ad hoc nature of a hearing. And in any event, if one looks at the test in section 78, and that's on MS 297 in this bundle,
Necessary for the proper consideration of the matter. Is that
exactly
the test?
so. Well, of course, you don't know what the matter is because you haven't seen the reports. So the hopeful sibling will be in the waiting room, not knowing whether or how what he or she wants to raise will fit with what's before the hearing. And there's no requirement, of course, to tell that person in advance. Yes. And Junior's pointing out, of course, that the chairman has an obligation to keep the numbers to a minimum. Now, I'll come back to that.
At the same time.
Yes.
Minimum at the same time.
Well, just kept to a minimum, 78.4.
At the same time.
Oh, yes, sorry, at the same time, it's kept to a minimum, yes. The alternative, of course, is 78.2b, where there is a totally discretionary permission to attend, which may be issued, provided the child or another relevant person doesn't object. But totally discretionary, there's no guidance. And that is, there's no way of predicting how any particular chairman will operate that. And in the absence of guidance, that truly is arbitrary.
Mrs. Scott, these are all, so it would seem to me, valid points. But why can't firm guidance to local authorities, implementation authority, firm guidance to safeguarders where they exist, firm guidance to principal reporters, and there is already now some guidance, firm guidance to chairs of hearings, if you've got guidance all the way around, times 4, wouldn't that solve it?
No, with respect, because whatever is in those reports will not be disclosed unless one is a relevant person. And if one goes to Mr. Moynihan's solution of Rule 61G, a direction for the disclosure can only be given by the hearing which is actually taking place. And then if one is going to have time to look at this, there's going to be a continuation or a deferral of the hearing. And there will be enormous pressures just to get on and make decisions. One ends up with a difficulty where there is, on the one hand, the need to make a decision in relation to a child, and the other, the need to be fair to the sibling who's only seen these reports for the very first time. And that's why I'm with Miss Brabender on this.
Informality and the ability to react to different circumstances are the hallmarks of these hearings, are they not? Do you foresee any compromise in those essential features if you introduce a prescriptive regime?
Well, of course, we have a prescriptive regime, and it's an exclusionary regime. And what I am proposing, and this is why I'm basing my submissions on proportionality, is that there is a proper consideration by a pre-hearing panel that admits siblings when it's proportionate and justified to do so. I'll come to that. That's my third point under this heading. My second complaint is that it's really for the first and second respondents to identify their objective in a test for relevant persons that excludes siblings who do not fulfill a quasi-parental role. And nowhere do the first and second respondents say, this is our objective, we pin this to the wall as the reason why we're keeping these people out. And of course, it's difficult for me to frame an argument when I don't know the objective. So I've got to have my best guess and perhaps come back later. But my best guess is based upon Ms. Dunlop's paragraph 24, which is extracted from what the Court of Session in a House said in the ABC case, that it's something to do with efficient operation of the system and thus the interests and welfare of the child at the heart of the system. Of course, that would be an entirely laudable objective. But what one has to do is then test this exclusionary criteria against that objective. So first of all, do we test it against numbers? And my submission is, well, no, you can't test it against numbers because the proposal is that siblings are invited. They can come along and sit there. There'll be a seat for XY, even though he won't have a fair hearing. There'll be a seat for him where he can occupy at the children's hearing. And of course, when one considers what Mr. Richardson says in AM's case at paragraph 37, there is AM faced with 3 social workers, 2 foster carers, a teacher, an advocacy worker, and a safeguarder, as well as her parents and their lawyers. And who she really wants is the person she's confided with about her difficulties and problems, and that's her brother. And she wants to have him support her, and she wants to see him, and see him under less restrictive circumstances. So numbers, with respect, is a difficult argument from learned friends if that's their objective. But of course, if they're trying to operate a floodgates objective, and one looks at what happened when there was a more open test based upon principal reporter against Kay before the 2011 Act came into force about 18 months later, 13 months later, 30 months later, 2.5 years later. We had then a very wide class of relevant persons capable of including siblings, and the only reported case was the V case that Ms. Brabender put before the court yesterday. So floodgates doesn't seem to work, but I don't know if that's the objective or the justification. If the justification is welfare, then the issue is whether siblings should be involved in a discussion that reaches the welfare decision. And so we're not concerned at this point with the substantive decision on contact or where the child should live. And what we have is a pre-decision which isn't easily susceptible to something that's a priori based on welfare and requires the exclusion of all siblings who don't have a quasi-parental role. So the welfare argument in my submission really doesn't work. And of course, one can argue this the other way and say that there will be cases where involving siblings is entirely consistent with welfare, because the children's hearing in its discussion should be working on reunifying the family and at least maintaining important family relationships. And that is not going to be possible if you have a blanket exclusion of proper involvement by the sibling. Now, I pause there to say that there is, of course, a mechanism to exclude a relevant person if the presence of that person is preventing the hearing from obtaining the child's views, or the presence of that person is causing significant distress to the child. And that's in Section 76 of the 2011 Act. I'll just give the page reference. It's Memory Stick 295. And then, if it's a question of views, and I'm conscious that there are different views in this family about the involvement of XY in these hearings, in my submission, that is a difficult basis to justify a blanket exclusion, because the views of the child who is subject to this CSO may be positive or may be negative. And if you have a blanket exclusion, one only provides for the negative. It doesn't allow for the child such as AM, who is a subject to the CSO, who wants her sibling at the hearing. And then there is an important point which is made most forcefully by Mr. Mitchell on behalf of LM about data, access to data. Now, my first point on that is that I'm at one with Mr. Moynihan, that this is not a GDPR issue, because the information will be part of a legal process and available in order to participate properly in a legal process. Notwithstanding its informality, the children's hearing is a legal process. But I also say that there are safeguards within the system. Because if one looks at section 178, and this is at Memory Stick 333, a children's hearing need not disclose to a person any information about a child to whom a hearing relates, or about a child's case, if disclosure of that information to that person would be likely to cause significant harm to the child. And then the provision for explanations and so on. And that is backed up by the rules of the children's hearing, which provide for that to be considered and dealt with, if necessary, in advance, and they're rules 15 and 16 at tab 4, and rules 84 to 87. I won't take the court to them, it's just that the rules do actually support that piece of legislation. And so the system is equipped to exclude information in appropriate circumstances. And I add to that, that of course there are Article 8 safeguards which respect the private life of the subject of data. And what I have in mind are the decisions taken in this jurisdiction, first of all by, I think he was still Mr. Justice Mumby, at the time of B, disclosure to other parties in tab 31, and also his later decision in 2014 in C against C, Court of Protection disclosure. And so there are Article 8 rights which may protect the data concerns of children.
What is the latter tab number?
The latter tab is 32.
32, thank you.
So my submission is that if I have correctly identified the objective, it is difficult to maintain that nothing less intrusive than a blanket exclusion will suffice. There are safeguards in the system. And it's difficult to maintain that a degree of involvement that lacks procedural fairness is necessary in every case in the interests of the system. And that takes me to my final complaint. And that is this. If one has an exclusionary rule, that means there is no possibility of striking a fair balance in the individual case. One simply cannot apply proportionality. The pre-peering panel, faced with an application from a person such as XY asking to be deemed, cannot undertake a balancing exercise because the test of significant involvement in upbringing, as the Sheriff Appeal Court has interpreted and applied it, simply presents a bright line exclusion of all who do not fulfill a quasi-parental role. They're out. Of course, it's an easy test for a lay panel, and one wonders whether that's what lies behind this particular provision. But it means that the structure of the system cannot afford effective respect to the Article 8 right to family life. If one was permitted to engage in a proportionality exercise and strike a fair balance in an individual case, the pre-hearing panel would ask questions such as, what is the nature of the family life enjoyed in this case? Does it require procedural protection? And that question arises directly from what Lady Hale said in Principal Reporter against Kay at paragraph 68. What is the significance of the sibling relationship in the case between ABC and his brother, or XY and the relevant sister? It deals with Lord Wilson's question from yesterday, how do we take account of the age of this sibling? It deals with, are there other rights and interests to balance? And I take in there the contrasting positions of LM, who doesn't want her brother involved. May not be determinative, but we can think of all sorts of situations where children are manipulated, but it's got to be looked at, or should be looked at if doing a proportionality exercise. And the position of AM, on the other hand, who desperately wants her brother involved. And then what are the circumstances that bear on this case that would justify the exclusion of somebody with a right to respect for family life from involvement in the discussion? And my complaint is that a proper proportionality exercise is not possible under the current statutory regime as it is interpreted. It is only going to happen if the legislation can be read or read down as permitting siblings, such as the appellants in these cases, the status of relevant persons. Now, I'm not saying they're necessarily going to be relevant persons, but my complaint is the structure of the system, as it is currently applied, doesn't allow it. And it's only if you cannot read or read down the legislation, the test of significant involvement in upbringing, to permit involvement on the basis of proper proportionality, a proper proportionality exercise, that I would then agree with Ms Brabender that the legislation is incompatible with the European Convention on Human Rights and outside the legislative competence of the Scottish Parliament. So it's my respectful submission that XY's question number 6 should be answered in the affirmative. Sorry, beg pardon. it's question 8 that has to be answered in the affirmative. Question 6 would only be answered in the affirmative if the court were to find that it was not possible to read or read down the test. Now, I've managed to say everything I need to say double quick. If I can assist the court further.
I think no questions. Thank you very much indeed. You've obviously reordered the timetable from the one that's in front of me.
Yes, there have been a number of versions of the timetable. What we've endeavoured to do is to allow the court to hear from those who are supportive of XY's position before turning to the principal reporter, the Lord Advocate, and those who are against XY's position. So Ms. Coates is to follow me.
Yes, that's good. Thank you very much indeed, Mrs. Scott. I've now got the revised timetable, which is not the one that I had. I was slightly taken aback to see you on your feet as soon as you were. Mr. Aitken, do you wish to follow?
Yeah.
Thank you. Ms. Coates.
Thank you. My lady, my lords, my lady, I don't want to risk detracting from the appellant's case by unnecessary intervention, and so I am going to formally concur with the case for XY. That said, XY's parents have consistently taken part in all the discussions concerning all their children, and they wished to be represented here. In common with most parents, XY's parents were content to advocate the central message of reunification of the family on behalf of the core family unit. But XY's parents recognise now that some siblings, such as XY, need to pursue their own Article 8 rights themselves. Firstly, because XY is an adult, they recognise he's a separate legal person, and it's clear to them he needs to represent himself, particularly, for example, in relation to any request by the hearing for provision of a medical report. And the same would be true if the children's hearing required any undertakings. Secondly, the parents were coping with wearing a number of hats, as XY's mother put it, but it was not until he was separately represented during the aborted permanency proceedings that he asked for unsupervised contact. And the value of him being separately represented became clear to his parents. Thirdly, representing siblings in care is not easy. Parents are not present at the sibling contact, and they are not equipped to challenge the reports. Discussing those reports during the parents' own contact sessions with their children is not conducive to good contact, particularly where siblings have different views. Fourthly, managing conflict between parties is problematic for parents trying to act in a representative capacity for a core family unit. So, for example, where one child has an issue with what information a sibling can see about them, parents have access to all the papers, and there is tension between them sharing relevant information with a sibling, and parents not wanting to upset the child. Separate representation would remove that issue from being for the parents to resolve, and it would be for the children's hearing to resolve. In terms of receiving separate representation, procedural safeguards are not met unless deemed a relevant person, but that may not be open to the sibling if they don't have a quasi-parental role. So for these reasons, and those in the written case, there are situations where it is not practically possible to rely on the presence of parents to provide the procedural safeguards necessary to protect a sibling's Article 8 rights. And unless that sibling can be deemed to be a relevant person, the sibling falls through the gap. So I invite my Lord, my Lady, to grant the appeal.
Thank you very much indeed, Ms. Coates. Thank you. Mr. Richardson?
My Lady, my Lords, and my Lady, the fifth respondent, AM, supports the appeal of her brother, XY. In short, she wishes XY to be deemed a relevant person in terms of Section 81, subsection 3 of the 2011 Act. Accordingly, she invites the court, in accordance with question 8 of the stated case, which is MS 81, Mrs. Scott took your Ladyships and your Lords to it, to construe the legislation so as to enable a non-parental family member, such as XY, who does not fulfill a parental or quasi-parental role, to be deemed a relevant person. I would adopt the written case submitted for the fifth respondent, and I would also gratefully adopt and concur with the submissions advanced by Mrs. Scott this morning, and with the similar qualification put forward by Mrs. Scott, I would adopt the submissions by Ms. Brabender yesterday afternoon. I would gratefully adopt her submissions in respect of the operation of the children's hearing system, and agree in respect of the practical problems that arise from that. However, I would concur with Mrs. Scott that it respectfully seems to me that the legislation is capable of being read compatibly. And it would only be if your Ladyships and your Lords were against or found that that was not the case, that I would move to the fallback position being her submissions in respect of incompatibility. In the time available, I would seek to do two things. The first, most importantly, would be to set out for your Lordships and your Ladyships the AM's position in relation to these matters, factual position. But then secondly, to briefly explain how respectfully seems to me that the issues before my ladies and my lords might be approached from AM's perspective. So to deal first with AM's position, I begin by observing that AM has been subject to the jurisdiction of the Children's Hearing since April of 2012. That is, since she was 8 years old. She is now 15. So perhaps the speed which my Lord Wilson identified has not been so successful in this case. Above all, she wants her family to be reunited. And I make these observations having had the benefit of meeting and speaking to AM in preparation for this hearing. Her impression is, whether rightly or wrongly, that she is fed up with people, however well-intentioned, that she has not chosen and with whom she has no personal link, being privy to information about her and making decisions which fundamentally affect her life. Her impression, whether correct or not, is that those people, whether the local authority, the Children's Hearing or others, have given scant regard to her views and to her personal struggles in care. She sees her brother as being and having been an important person in her life. When she has experienced difficulties in her life, she has been able to confide in him, and that was a matter that was touched upon by Mrs. Scott in her submissions. Accordingly, AM is adamant that she wishes XY to have relevant person status in respect of her case before the Children's Hearing. And at least since she has had legal representation, which is since June of last year, she has consistently held that view. AM wishes XY to participate fully in the Children's Hearing and in the decision-making regarding her welfare. Her view is that allowing her older brother relevant person status will afford her a greater ability to advocate for herself before the hearing. In short, she sees him as being someone who will be on her side in the Children's Hearing. And against that background, I would advance a single proposition, which is that Section 81, subsection 3, falls to be construed in such a way as to give due weight to the views of the child concerned. I would not understand that proposition to be particularly controversial. I would hope it was not. It is vouched by the legislation itself. Section 27 of the 2011 Act, which is in tab 2 of the authorities volume, or MS 286, using the XY numbers. Section 27 states that it begins, subsection 1 of the section makes clear that the section applies where by virtue of this act a children's hearing, pre-hearing panel or the sheriff is coming to a decision about a matter relating to a child. And then for my purposes, the relevant part is subsection 3, paragraph C, which provides that the children's hearing, pre-hearing panel or sheriff must, so far as practical and taking account of the age and maturity of the child, have regard to any views expressed by the child. And it respectfully seems to me that that section has application in the present case where, when one considers section 79, subsection 2A, Roman 2, Mrs. Scott took my ladies and my lords to it. It is the section which introduces the provisions relating to deeming, and it's the MS number is 299. It's still in tab 2 of volume 1. But the legislation expressly provides that the child themselves may, as it were, nominate a person to be a relevant person and to the principal reporter, and in those circumstances the principal reporter must put that person before the pre-hearing panel. So in that situation, it respectfully seems to me that having regard to the views of the child plainly has a significance in the present situation. My ladies and my lords may have noted that rather than using the formulation from the statute, having regard to, in formulation of my proposition, I took the formulation from Article 12 of the UN Convention on the Rights of the Child, to which Miss Brabender took my ladies and my lords yesterday afternoon, and that is, for reference, tab 12 in the Safeguarders, that's the 6th respondents bundle, MS 474, and it is there that the formulation of due weight comes from. So taking that as a relatively, I would hope, uncontroversial proposition, it respectfully seems to me that the critical question for the court in XY's appeal is whether, properly construed, section 81.3 prevents somehow effect being given to AM's views that her brother be deemed a relevant person. And approaching the matter from the standpoint of the child AM herself, as I would seek to persuade my ladies and my lords should do, represents a reversal of the position adopted by the Inner House. The Inner House approached the question as to whether section 81.3 required a person in XY's position to be accorded relevant person status. Whereas, in my respectful submission, the question should be, why shouldn't XY be deemed a relevant person when one takes into account the views of the child? I think Mrs. Scott was pointing to the same kind of reversal when she referred to my learned friends for the first and second respondents looking down the wrong end of the telescope. It's approaching the question from the wrong perspective, in my respectful submission. And I would submit that for the reasons which Mrs. Scott has set out at some length, and I wouldn't propose to repeat, that the answer to that question is no, there is nothing inherently in the legislation which prevents XY from being deemed a relevant person. And that, in my respectful submission, is the answer, whether one approaches it simply by looking at the legislation itself, or whether one looks at the legislation as construed through the Article 8 jurisprudence. The wording of the provision itself, 81.3, significant involvement in upbringing, is, in my respectful submission, capable of being construed to include those who were involved in the sense of being present during the upbringing, being influential without necessarily requiring the fulfilment of a parental role. And in this regard, I note, albeit as an alternative, it's an alternative position adopted by the first respondent, that in his written case, paragraphs 63 and 66, that is, MS references are 134 and 136, that my learned friend Mr. Moynihan accepts that such a construction on the wording of 81.3 is possible. And such a construction, in my respectful submission, is also, would recognise the fact that the legislation itself allows for two alternative routes to relevant person status, one being the section 200 provision which deals with parental rights, and section 81.3, the deeming provision, which allows for a different approach. And that dichotomy, in my respectful submission, is also seen in the discussions at the committee stage of the 2011 Act, which were very helpfully referred to in the written case for the safeguarder, the sixth respondent, and those there's an extensive quotation in the written case for the sixth respondent, and the actual committee discussions are contained in the authorities at tab 16, and the MS number for that is 699. So, in my respectful submission, to recognise the fact that one has the parental rights allowed for, as it were, in section 200, it is reasonable to infer that section 78 could be intended to go beyond that scope. And I'm grateful at section 81.3, I apologise. And again, for the reasons that Ms. Scott has already explained, such a construction is consistent with and reinforced by a consideration of the Convention. Thank you. So, and that's for the reasons that Ms. Scott has set out, and I would respectfully adopt her analysis. It respectfully seems to me to become a question of justification, and for the reasons that Ms. Scott has already submitted, I submit that no justification has been offered by the first and second respondents, and for those reasons, no justification falls to be upheld by my ladies and my lords. And so for those reasons, I would respectfully invite my lords and my ladies to allow the appeal and to answer question 8 in the affirmative.
Thank you very much, Mr. Richardson. Thank you. Mr. Moynihan, you'd like to have the lectern, wouldn't you?
Ms. Gilchrist didn't want to add anything, did she? She's out.
Ladies and lords, in inviting the court to refuse these appeals, I propose to look at matters really in an overlapping way, but I will address incompatibility, the question of the binary, so-called binary nature of this system. I'll give you some statistics to give you a perspective. Some of them are here. The main emphasis of my submission will be to stress to you the flexibility that's in this system. And finally, I will give you 4 practical reasons why the Scottish Children's Reporters Administration objects to these particular individuals or siblings more generally having relevant person status. I will indicate their practical difficulties. One point, though, that I should make that is worth mentioning, and it's in the Inner House judgments. The submission I'm about to present, and I have presented in the court below, makes the responsibility of the Scottish Children's Reporters Administration more onerous. More onerous. I'm not suggesting, and indeed completely rule out, an exclusionary approach, a bright line test. It is akin to what Lord Wilson spoke of yesterday, a bespoke arrangement, or more particularly, bespoke arrangements, plural. And the Inner House has accepted that rejecting these appeals does in fact make the system more onerous, more geared to individual circumstances. And that is why giving you the briefest of statistics is helpful. So far as children's hearings, and some of the statistics are in Brandon Friend, Miss Brabender's submission. But there are 23,000 referrals a year to children's hearings at latest figures, involving just under 13,000 children. So 23,000 and 13,000 means that some children are, of course, referred to children's hearings more than once in a year. There are 31,500 children's hearings per year. And last year, just under 3,000 compulsory supervision orders were made. Children's hearings do not just concern neglect by parents. They are a means by which children may be diverted from the criminal justice system. So children who commit crimes may be referred to the children's hearing system and dealt with in that system rather than being brought before a court. And some of those 31,500 hearings will concern such children. As one might imagine, with those numbers, there is not an infinite variation, but there's a very great variation in the circumstances of the children, and indeed the families, and families plural in some cases concerning these children. And it's because of those variations that a bright line approach advocated here, which is that a sibling with family life which may be affected becomes such an open-ended category as to create the practical difficulties that I will come to. But where I depart, principally in opening up in what is onerous, where I depart from Brian and Friends, Miss Brabender and Mrs. Scott, is that the principal reporter does not look at the terms of the legislation in isolation, construing them as if an exclusive code. As one would expect, the principal reporter has to look at them in terms of the common law, and in particular, natural justice or fair procedure. And that, to be beyond doubt, is, of course, if an order is to be made by a hearing that restricts contact of one child with another, that is affecting the rights of both, and natural justice or fair hearing would suggest that an opportunity for a hearing should be afforded to the two children. And that, we will see, is reflected in a practice direction. So common sense is also applied. The common law that Article 8, procedural right, is obviously incumbent. And I'm grateful to my friend Mr. Setright for expanding the discussion. The UN Convention on the Rights of the Child, in particular Article 12. These are all factors that have to be considered. And this is where this topic goes beyond the narrow bounds of family law into that, as Lord Roger might say, streams flowing together with public law and international law issues at stake. And practice has developed. It's often, in relation to GAYDAN, which again Mr. Setright has produced, one is familiar with the famous passage of Lord Roger about going with the grain. There was a second, in fact, 2 paragraphs in what Lord Roger said that, again, grateful to those behind me, Mr. Setright, members of this court yesterday, in effect, gave effect to in the case of R. What Lord Roger said in GAYDAN is he picked up that Section 3 says that it must be read and given effect, and not read and given effect by the courts, so holding on for 2 years while this court gives a ruling. It must be read and given effect by those on the ground, by public authorities, children's reporters, and the likes. And that is why practice has varied, moved on to accommodate what, from a public law perspective, was simply a straightforward natural justice issue. You should not make an order that affects A, B, C, or X, Y in his absence. And I now appreciate, of course, that it's perfectly consistent with Article 12 of the UN Convention on the Rights of the Child, and I've been shown 2 English decisions, of course, the cases of HH and ZH, in which members of this court participated. What I take from those cases, which is of fundamental importance to understanding this structure, is that both my Lady Hale, I believe in HH, and certainly my Lord Wilson in ZH, referred to the general commentary on Article.
Other way around, Mr. Morton.
Other way around. I'm grateful. Referred to the general commentary on Article 12, which is very incisive in this case. It stresses that the right of the child to be heard is a right. It is not an obligation. It is a choice. That translates directly into the structure of the children's hearing system. A relevant person has extensive rights, one obligation, and of course we know it can be excused. That's to attend every hearing. Why? To use the phrase of my lady in the chair in Principal Reporter, because they have something significant to contribute to the solution for the child. What makes a parent or someone with parental rights, because these days we tend to think more of rights, the Human Rights Act, what makes them stand out? The Children's Scotland Act 1995, Section 1, begins with parental responsibilities. They have responsibilities. Section 2, rights are conferred for the purpose of discharging those responsibilities. Why attendance is compulsory is that those people who are relevant persons are considered to be those with the rights and responsibilities to contribute to the solutions for the child. Siblings can be and are relevant persons. Can be and are relevant persons. There are examples given. The one that I've mentioned, I've not produced the case because it doesn't really merit being produced, but was the example of an older sister who was bilingual. The mother spoke only Portuguese, the referred child only English. So if the family was to be reintegrated, the older sister really played a critical part. And the sheriff in Edinburgh had no difficulty in saying that sibling must be a relevant person. But for these siblings here, X, Y, and ABC, what have we heard? We have heard that they are wanting to protect, assert, and affirm their rights, their right to contact, their right to family life. That is a right, and I don't dispute it, but it does not carry the same responsibility that necessitates relevant person status. Their right can be and is met by giving them an opportunity to participate. And the point that's perhaps worth stressing, and it's in my written case, the proper opportunity to participate, which this court and principal reporter took from W, I don't quarrel with. But what no one has been able to point to, and significantly no one has pointed to, is any precise definition of what a proper opportunity actually is. And the same, and I will not try to attribute this because I will get the cases the wrong way around. In HH and ZH, I did notice that members of this court were trying to grapple with the question how a proper opportunity could be afforded. In some instances, it will involve what is there referred to as party status. In other instances, it will involve simply reports that convey the rights of the child. And I also noticed there's a third case, it's not in the bundle, again, a case of LC, a Hague Convention case. And what Lord Wilson, if I remember correctly, in that case spoke of, is that introducing children into the forensic arena can be damaging to them. And interestingly, the Lord, I believe in that case, contemplated that while one of the siblings was a party, the guardian might protect the child by shielding her from documents that were not necessary. So this question of what is a proper opportunity to participate is not a set requirement. It varies. And in the children's hearing system, there is not a binary requirement. It is not the case that if you are a relevant person, you have full participation, otherwise you have none. Full or none. That is not the case. It might be thought to be the case if one simply took the statute away and sat in a darkened room and read nothing but it. But as soon as one reads it, as one must, with the common law, Article 8, by virtue of the Human Rights Act, and the UN Convention on the Rights of the Child, to read it compatibly with international obligations, it opens up. My Lord Wilson asked how views of the child can come before a children's hearing. The answer is that they can come in the form of the social work report. And I differ from blind and friend Mrs. Scott, who looks to Schedule 2, which is the report about the child's plan. Schedule 1 tells us, and I appreciate it's not before the court, Schedule 1 looks to the report that the social work authority must prepare when a child is about to be, or may be, or is looked after And looked after is a term where a child is under the care of the local authority by various routes, including a compulsory supervision order. So a child is looked after. As one would expect, Schedule 1, paragraphs 7 and 8 require the local authority to consider the sibling relationships and the contact between siblings.
You say we haven't got that in the
No,
Bible.
we haven't.
Well, we better have it in.
Precisely. I was going to offer a note on it, but yes, Your Lordships better have it. The second point that relates to this before we come to the guidance is in the Children's Hearing Scotland Act, which you do have, Section 29A does have a responsibility on the children's hearing to consider contact measures. In relation to the XY papers, 29A is at page 287 for my Lord Wilson, page 29 of the paper version. So 29A, a children's hearing must, when making, varying or continuing or compulsory supervision order in relation to a child, consider whether to include in the order a measure of the type mentioned in 83.2G. It's again a sort of ping-pong game, but if one goes to 83.2G, one finds a contact direction. But I should stress as part
Where
of
do we find 83.2G?
83.2G already is at page 305, again in the
Sounds about right.
Y, page 305. Right towards the foot, my lady, G, a direction regulating contact between the child and a specified person or class of person.
So it's open-ended.
It's open-ended, my lady. But as Miss Brabender told the court yesterday, and this is an important point to stress, compulsory supervision orders do not necessarily contain contact directions. They do not necessarily contain contact directions. In many cases, contact works perfectly satisfactorily on an informal basis. So we're dealing, even in our case, with a minority of situations.
So are you saying when we look to Section 29A, children's hearing must consider that statutory duty requires it to exercise any incidental powers which will enable it to do that job properly?
Yes. And we can see, and I make no bones about this, Lord, in two respects. What I'm going to show you is a practice direction, dates from September of last year. It's consistent with the GAIDAN, the R&R, the public authority reflecting on its obligations and adjusting practice. And I should make it also clear when I come to Rule 61.1G as a means by which to provide documents. My learned friend, Miss Brabender, called it theoretical, said it's not applied in practice. My written case makes it clear. It has not been applied in practice. 61.1G is what, when discussing this case with the reporters preparing for this hearing, has come to be identified as a possible solution to the question of releasing documents in whole or in part if essential for a fair hearing. So again, it's following through natural justice, Article 8, and the Convention. 61.1G has been a rule that's been identified as needing no instructive interpretation. It's just a plain term. And if I can identify how this arises, there will be cases now where a recommendation in the social work report is to regulate contact. If there is such a recommendation regulating contact and the sibling is mature enough and not a relevant person, notification is given now, reflecting the fact that the siblings' rights are engaged. There will
Do I
also-
understand you to say that you accept that 61(1)(g) has not been used so far?
Yes, my Lord.
Well, why is that?
I think because until the focus of these cases, the practitioners have been looking at the rules in an enclosed way and simply saying the rules, the statutory rules say all papers are given to relevant persons subject to 178, no papers given to anyone else. As soon as one looks at it in a broader way, one thinks there may be some cases where a fair hearing requires an individual to have access to papers. How can that be done? So that's the answer, Lord. It is the product of continuing thinking on how this system can be applied, GAIDAN, R&R, how can this system be applied compatibly with the rights of all concerned? And
Are you coming on to show us Rule 61(1)(g)?
I will do, lady, in a second part. Perhaps if I take
You
a
wanted
step
to
back.
get us there,
Yes,
I know.
I will get you there. Because, as I've said, there will be cases where contact is known to be an issue coming up. Reporters, as of September of last year, so courtesy of the exposure of these cases, now give notification to siblings, if they're sufficiently mature. As in the case of ABC, in fact, on the 7th of September, there was no recommendation to change contact, but in fact, the hearing went on to consider making a change, and there was an ambiguity. The decision was no change, the reasons suggested change. Practice now that I will show the court is, if the matter arises unexpectedly in the course of the hearing, the reporter will alert the children's hearing to the difficulty of an absence of notification. And in answer, this is why I've parked Rule 81G, 61(1)(g). It is possible that when that arises, the hearing will defer a decision, will adjourn. If it's a review case, it adjourns under section 138. And it is not at all unusual that an adjournment is sought so that a report is obtained, for example, more specifically in relation to contact. And indeed, I'm told a safeguarder might even be appointed at that stage with a remit to consider contact. That's what happens. And it's for that reason, my lady, I'll come to Rule 61(1)(g), because that tells us the power that the children's hearing has in the event of an adjournment. So far as the practice direction is concerned, if the court looks to tab 56, it will be in volume 4, and the practice direction, be a moment. Yes, sorry, in the XY papers, it's page 1783. I should stress to my ladies and my lords, for the avoidance of any doubt, that what I'm going to refer you to, which is section 9, came into existence informally in September of last year. For my Lord Wilson, it's page 1525 in the paper version, my Lord.
Well, who makes this practice direction and what validity and force does it have?
It's a practice direction by the Scottish Children Reporters Administration, so it's a practice direction to reporters. children's hearings, my lady, are subject to separate administration being an independent panel. So this is not binding on them, but is binding on reporters. And I will read something from the guidance given to children's hearing panel members.
Yes, we need to see that. But,
well, precisely. So,
but could you give us the name of the organisation again?
The Scottish Children's Reporters Administration. It is an alternative name, my lady, for the principal reporter. The principal reporter is the head of the Scottish Children's Reporters Administration, so it can be said I appear for both today.
Of course, reporters are a statutory office.
Yes, ma'am.
But what, I mean, there are rules about practice directions given to courts. I mean, they have statutory force. Does this have any statutory force? What's the power? What happens to a reporter who doesn't do it?
The answer is that the children's reporter, the Act speaks in terms of the children's reporter doing various things.
Mm-hmm.
He delegates his function to various people, reporters, and the reporters discharge his functions in accordance with guidance and practice directions which he issues.
At some stage, Mr. Moynihan, you should explain to us why in ABC's case, in the outer house, the principal reporter suggested that Section 81 had to be read down, and I think the Lord Ordinary accepted that. You are presenting a different case from that presented to her by your principal reporter.
Rod, again, I was not instructed then. I don't believe my position's in conflict. I believe that the position adopted in the outer house, I'll say this and then check, was that there was no incompatibility in that ABC had been afforded a proper opportunity. However, if there was an incompatibility, Section 81.3, so it's the same as my position today. And what was being suggested then, focused on Section 81.3, was to read Section 81.3 in the manner of principal reporter against K, if one had to. The innovation, which I've introduced, is Section 126 as an intermediate step.
That sounds like a reasonable response, Mr. Moynihan. Let's leave it at that, unless it's challenged.
Those who are behind me are nodding.
Very well. Thank you.
So far as Section 9 is concerned, I've drawn the court's attention in my written submission to paragraph 9.2, which is notification, and of course geared to Section 78. But notification, the reporter is to invite anyone who has established family life in an ongoing relationship with the child, sufficient age and maturity, where the hearing is likely to consider including a contact direction about them in a CSO for the first time, or to vary a contact direction about them in a CSO, or the person has made clear that they want the hearing to consider their contact with the child. So that is Mrs. Scott's question of someone who actually wants an order to regularise contact. For example, the local authority is not giving them as much contact as they want. So if their view is known, then this requires notification to them for the hearing. And 9.3 is the one with apology I'd not mentioned. Over the page 1784. Within hearings, the reporter is to be alert to situations where the hearing is considering including for the first time or varying a contact direction in a CSO in relation to a person with established family life and an ongoing relationship with the child. In most such cases, the person will have been invited by the reporter, but there may be cases where the consideration of the contact direction was not anticipated in advance, or where the person was not of sufficient age and maturity to be invited. In these circumstances, the reporter is to take the view that the hearing should satisfy itself, subject to age and understanding of the person. It has the views of the person, directly or indirectly, in relation to their contact, or if not, the person has been given an opportunity to provide their views. The hearing can decide to defer to give the person the opportunity to attend or give their views directly or indirectly. An interim decision can be made if necessary. So that deals with the situation where, for whatever reason, someone has not been invited, but the topic arises in the hearing. That is exactly what one would expect of natural justice or Article 8 and Article 12 of the UN Convention on the Rights of the Child. The child's view ought to be heard. And that links then to Rule 81(1)(g).
81?
Sorry, I keep saying 81.
You keep saying
apologise.
81, you mean
I
61.
keep saying 61. I apologise,
sure.
lady.
Just before we go there, what's the default position if you've got a compulsory supervision order and the child is placed away from home? What's the default position? Is the default position that there's a presumption that the child is to continue to have contact with parents and significant others, or is the default position that the local authority can decide what on earth is to happen?
Well, the default position, lady, in law is that the local authority decides.
Exactly. So every compulsory supervision order potentially deprives siblings of contact with one another.
Potentially, lady, yes.
Yeah. In fact, that's the default position.
That is the default position.
Yeah.
It puts the discretion in relation to contact from the parents to the local authority. And as I've said, in the majority of, I'd better be more careful. In many cases, matters are left in that manner, and there is no specific contact measure included in the CSO. So,
And that might be because it's all perfectly satisfactory and everybody's getting on fine, and it might be because the local authority have made no or very limited arrangements and nobody has plucked up the courage to challenge them.
that is correct.
Yeah, thank you.
And if, the lady, someone does pluck up the courage, then as we've seen, the practice direction envisages that the reporter will pick that up and will raise it, give an invitation to the children's hearing to enable that to be addressed. Lady, so far as Rule 61(g) is concerned, in the XY papers, it's at page 397. Perhaps if I take the court to page 396 to begin with. There are separate rules applicable to each type of hearing. For our cases, the significant one is section 138, which is a hearing for review of a compulsory supervision order, so 138. So Rule 61 applies. And 138(2) is specifically where the decision has been deferred. So the 61(1) is telling us what may happen where a decision has been deferred. Point A is that a safeguarder may be appointed. And then over at G on page 397, give any other direction on any other matter as is necessary to enable the hearing to make a decision on whether to make a compulsory supervision order, and if so, the measures to be included in that order. The words, the measures to be included in that order, take us to 83(1)(g), for example, a contact measure.
Mr. Moynihan, I'm afraid I didn't check all the sections mentioned in the opening line of Rule 61(1). Does 61(1) bite even before grounds are accepted?
Yes, my Lord.
It does.
Yes. And
Okay.
that is section 91, if your Lordship sees in the heading. Oh, sorry. No,
That was
Your
what
Lordship's-
worried me,
no,
Mr. Moynihan.
no, yes. So Rule 61 does not apply where grounds have not been accepted. There will be haven't noticed the particular rule that applies in that context, my Lord. There are separate rules. I'm looking at 59, but I can't see that it immediately applies.
Well, that's a bit of a concern about your point,
Yes,
because we're thinking of this at the preliminary stage before grounds have been accepted.
not in these two cases, my Lord. In these two cases, the grounds have been accepted.
Well, oh, I know, but
Yes.
We
you
know that, but we're looking at we've
Well,
got to look at the thing in the round, haven't
we
we, as a
have.
matter of principle.
I think that, well, I accept that. I think, my Lord, I think the honest answer is the rules are sufficiently complicated. I've taken a bit of time to track through to 61(1)G. I haven't tracked through every other, but no doubt those behind me will see if there is a rule that would apply in that situation.
Well, would you accept that there should be such a rule?
Yes, my Lord.
Yeah.
Again, my Lord, given what I've started with, if one has to, in Gaedan terms, Lord Roger, at paragraphs 106 and 107, give effect to these rules in a manner which is compatible, the answer is yes. Even if that means, as one knows, turning the rules on their head to achieve that. But 61(1)G would normally apply quite commonly in a situation where, for example, contact has become a live issue. If it's not been adequately covered so far in a social work report, the children's hearing can direct that a social work report be provided on that specific topic. They can appoint a safeguarder who would report again on contact. It's a variety of provisions that apply. And as I've said, in answer in particular to my Lord Kerr, it has not been used to date, but could be used in the manner I describe if access to a particular report were critical. But in these cases, in ABC and XY, I have made the point, and I adhere to the point, that there was nothing exceptional applying here in relation to contact arrangements. No one, and I appreciate ABC and XY will say they have not had access to these reports. They haven't. But neither of their parents in ABC with written submissions, and here we have in Miss Coots and my learned friend Mr. Richardson and Mr. Mitchell, people who represent parents and children, no one has suggested that there is anything in these reports that's in any way determinative of the question of contact. This is simply an ordinary discussion about what amount of contact is in the best interest of, in particular, DEF as a young child with particular needs, and in the case of XY, an individual, an adult brother who's in the area. So there's nothing special, and I do make the point in my note of argument. Neither XY nor ABC has suggested a breach of natural justice in denial of access to any of these reports. These are what, in a different context, Lord Roger spoke of as straightforward cases. If I can progress beyond those opening comments, just to show the flexibility in the system. In addition to a relevant person, at each hearing, the statute, section 78, allows the relevant person and the child to have a personal representative there. In XY, It will be at page 297. For my Lord Wilson, page 39. So 78 is a recurring, 78.1, the child. B, a person representing the child. C, a relevant person. D, a person representing a relevant person. So that there's opportunity for personal representatives. Now, why I mention that is it's in the Statement of Facts and Issues, and it's agreed. At the two hearings in September and December in ABC's case, one of the older sisters, who equally benefits from the same contact measure as ABC, was present as the personal representative of the mother. So there is a means by these provisions for other individuals to be there, fully participant, and indeed an older sibling with equal interest to ABC was present at both of these hearings.
Mr. Morgan, I'm not entirely understanding that, because 78(1)(c) and D are talking about relevant persons.
Yes, sorry.
And we're talking about the rights of a child outside the realms of relevant person.
Sorry, my Lord, I apologise. The mother is, of course, a relevant person.
Yes, of course.
The sibling in this case was present in the capacity of the personal representative of the mother. So in fact, my Lord, all I'm indicating, I apologise, I've changed track slightly. I'm indicating to my Lord the range of ways in which siblings may have their views reflected. First, social work reports. Secondly, a sibling, and we have seen it here, can be there as the representative of the parent. And to meet Miss Coote's point, of course, one would expect the adult sibling in that situation to be able to reflect both the interests of the parent and her own interests in a contact measure. There's no conflict between them in this regard. So that's one possibility.
Well, only if there's no conflict.
Only if there's no conflict, my Lord, yes. Only if there's no conflict. And of course, if the third level of it, my Lord, is if there is conflict, then section 78 is the measure, and I've shown the practice direction. In answer, again, to my lady in the chair about children's hearings, and I've been given this information by those instructing Miss Dunlop, there is guidance given to children's hearings, and because I alone have it, I'll read out the part. The children's hearings guidance, and it's paragraphs 826 and 827, says, there is no statutory requirement for a children's hearing to think about sibling contact in the same way as they must consider contact with those with parental responsibilities who are relevant persons for the purposes of children's hearings. So stop, that's adverse, but it continues. Panel members should have information about a child's relationships with their brothers and sisters and give careful consideration to how these relationships can be maintained and protected. The key considerations of the hearing will be identifying all the child's brothers and sisters, including those who have a similar role in the child's life, such as children brought up in the same placement. The views of the children about their relationship and existing contact provisions. Promoting face-to-face contact where possible. The practical and emotional capacity of carers to facilitate contact. How contact can be achieved in as relaxed and natural manner as possible.
So, do you not think that that's a document that we ought to have?
Yeah, again, lady, yes, and I apologise that some of these things have just arisen in the course of discussion. So yes, that's the second point.
Surely
And
not.
also a clear idea on its status.
Yes.
Yes, yes, ma'am.
So who's provided that guidance?
I understand that that is the children's hearings guidance.
Who by?
Is it again new, reactive to all this litigation, Mr. Moynihan?
I think I'd better pass over to...
In due course, she
Well,
may.
in due course, it'll be explained.
Yes, my friend Mr Dunlop is the principal, or the conduit, I think, unfortunately, that she'll need to get the answers. But it certainly is, there are apparently 6 copies available for the court. We'll have to make other copies available for others. So there are, therefore, for participation, short of relevant person status, there would be an expectation that the social work report would deal with siblings and contact. That's Schedule 1 of the Looked After Children's Regulations, paragraphs 7 and 8. If not, the principal reporter can in fact ask for information. There are various statutory provisions, and I will give a note about these. There's a range of statutory provisions.
Well, we'd like a note, and we'd like all the statutory provisions and documents on which you're now relying to say that the system is fine, so that we can assess for ourselves whether the system is fine.
Yes, I'll give a note, Lady, rather than...
I mean, this has been your case for a long time. I'm amazed that we haven't got this material.
Well, Lady, until some of what was being suggested yesterday and indeed today, in particular, in relation to this, I confess it was Lord Wilson's question about how social work report, what requirement there is for social work reports that prompted this. So I accept. And Lady in the chair, I accept that I should have had this earlier, but it's prompted by that question yesterday.
And the Schedule 1 to which you were referring, have we got that?
No, Lady.
No? Well, we need that, don't we?
We don't have the Looked After Children's Regulations, as far as I'm aware. Sorry. So we have the social work report, we have the opportunity for siblings to be personal representatives of a relevant person, we have section 78, which operates in particular in light of the changed practice, which I showed in the practice direction for the reporter. All of these are means short of being a relevant person. And in my respectful submission, they achieve a proper opportunity. In particular, my learned friend Mrs. Scott suggested that someone might be invited, but the chair refused to allow them to participate. To that, there are 2 answers. First of all, it has never happened in the context of ABC and XY. The occasions where XY has been absent has been through his own choice. And secondly, one would expect, reflecting the guidance which I've shown the court, section 9, that the reporter would caution the children's hearing that to proceed in absence of a child who has been invited because of their rights to participate, to proceed in absence of that child would be unlawful. And one would expect a children's panel to take that very seriously indeed. And if they did not, then there is no appeal, but it would be an unanswerable judicial review if someone proceeded, if a hearing proceeded, ignoring the rights of the child and contrary to advice. Why then do I say very briefly that there are good reasons not to make a child, a sibling, necessarily a relevant person? First of all, I stress as part of the flexibility, contrary to what my learned friend Mrs. Scott said, this is not 81.3 an exclusionary rule. It is not. Siblings are, from time to time, made relevant persons. Ascendants, in particular in principal reported against Kay, the court looked at situations of grandparents. Grandparents are, from time to time, made relevant persons if they apply. Aunts and uncles can be made relevant persons. It is not an exclusionary rule. And perhaps to give the court the most up-to-date position, because I'm stressing matters should be approached with common sense, The up-to-date position is not the decision of the Sheriff Appeal Court in these proceedings, nor indeed the case of Gary, which is cited. The up-to-date position is a case called CM. In the XY papers, if I ask the court to look at page 1142, CM was a case where a foster mother applied to be a relevant person, and the foster mother's application was granted. At page 1142, this is the Sheriff Appeal Court, paragraph 10. We take the view that the Gary test, if that is what we may call it, has been somewhat finessed and simplified in CF v MF, a case in which we were also referred to today. Perhaps the test can be encapsulated by considering paragraphs 3 and 5 of Lord Drummond-Young's opinion, where he makes certain observations on the analysis of this test. He refers to the number of cases in which sheriffs have subjected legislation to elaborate analysis and have added substantial glosses to what should be a straightforward procedure. Standing the fact that it is accepted and emphasised in CF that the panel are primary decision makers, we think it important to emphasise that the test as referred to in CF should be applied in a practical, common sense manner, because that is what we would wish and expect of that panel. In paragraph 5, Lord Drummond-Young takes the view that section 81.3 should be treated as a relatively straightforward test, which should be applied in a practical and common sense manner, subject only to recognition of the procedural importance of relevant person status.
So do we have CF and MF?
Yes, my lady, CF and MF is in the bundle as well.
Because I would have thought that what the Inner House says about matters is even more important than what the Sheriff Appeal Court says about matters.
Well, and that is correct, my lady. Simply that I'm showing the court the application of it.
Yes, but it'd be good to know what,
yes.
what the authoritative statement of the test was.
Yes, I'm learning, friend. Ms Dunlop is going to go to CF, but if
if Miss Dunlop's going to cover it, fine.
The point is, none of these rules are applied with the rigidity that anyone has suggested, and may I make it clear that I adhere to the position that's in my written case. So far as AM's particular views, so eloquently put by our friend Mr Richardson, and indeed her contrasting view of that of LM, I confess, are quite moving in relation to it. There has been an oversight when these cases were in the court below. AM has herself a statutory appeal that ought to have been considered at the same time as XF's appeal, XY's appeal. It wasn't due to an oversight. AM's appeal still has to be determined. The personal considerations that she has so eloquently put before the court are not in the stated case. They've not been canvassed before. It will be dealt with on its merits in due course. And it's consistent with what I've said. I'm not suggesting that it's conceded that XY should be a relevant person, but at least the merits of it on the argument that has been presented will be heard. The only question in the XY case is the legislation incompatible? Is there a devolution issue? And for the reasons I've submitted, I submit that it is not. And in my written case, sensibly operated, it can be compatible. I mean, sensibly operated, adapting to the needs of natural justice, Article 8 and Article 12 of the Convention. It can be, and it has been. We have seen the evolving position in relation to Section 9 of the Practice Direction about notification and handling contact, and my submission about Rule 61(1)(g). If I may just cover the practical reasons very briefly why the reporters are against these particular sibling applications, and they do pick up what is said by the Sheriff Appeal Court about the procedural implications. First of all, there is a concern that to make a sibling who does not meet the test in 81.3, to make the sibling a relevant person, distorts family relationships. It makes, in relation to a sibling-parent relationship, it puts the sibling on the same level as the parent in participation at the hearing. So the sibling receives all of the information that the parents receive, subject to only to section 178. And 178 looks at significant harm, but significant harm on the referred child. The point raised in the ABC case that there may be some information about the parents that it would be better that ABC not be aware of. The point that Lord Wilson had in the LC case of the guardian protecting the child. Section 178 does not apply unless one applies creative thinking, which I don't exclude. ABC would get information that all concerned seem to accept it's in his best interest not to receive. If he's a participant, that problem does not arise because he does not automatically get access to the papers. And of course, in what ordinary family, without state intervention, are children consulted by parents about decisions that affect their siblings? Not normal.
Are you giving evidence, Mr. Moorhead?
No, I'm asking a question rhetorically, but yes. I will not go into how many siblings there are in my family, but if I go high enough up, there are too many to count.
Well, we have an insight. We have an insight into the Moynihan family.
It's not so much the Moynihan family, my lord. It's the McGill family, my mother's side. But in any event, I have a fair amount of involvement in siblings and collaterals. But also, and more importantly, to be constructive about this and come back to this particular case, it distorts the relationship between siblings. It is, and I've said, a matter for another day that AM wishes XY to be a relevant person. Again, very moving, I suggest, is LM's own statement that she does not wish XY. And coming back to Article 12 of the Convention, where she has a right to speak but no obligation, it's entirely natural that she's very reluctant to spell out her reasons. It would be absurd and indeed inhumane to ask someone to spell out their reasons because it would be so damaging. Mr. Setright, in his written case, reminds us of the third sister who's in the care system, the youngest of the three, who is EM, who, Mr. Setright reminds us, simply says, I want XY to be my brother. XY to be my brother, not a relevant person. And again, in situations in particular, when my learned friend Miss Brabender was talking about notification, wanting blanket notification to siblings to give them the opportunity to participate. We come back to the statistics. It's not just care, family care. It can be children involved in alleged criminality. So drug taking or underage sex or something of that sort might be referred to a children's hearing. Again, without giving evidence about my family, in what ordinary family would we expect that one sibling would be told by the parents the details of the allegation against another, particularly if it's at the stage of a disputed allegation? And yet, if they're a relevant person, that's what comes. So there is a grave concern about distortion of the relationship between the parties. And of course, that distortion is avoided and matters kept proportionate if the alternatives that I've mentioned, social work report, personal representative, or Section 78 is used, because there, that simply gives XY the means by which to assert, and ABC, their own legal rights. And of course, in asserting their own legal rights, conflicts may arise and they have to think carefully. One of the points the safeguarder made to the inner house in this case, which so affected the conclusion of the inner house, is that she said that looking at it as a safeguarder, XY had to think very carefully about his continual applications and what that would do long term with the relationship with his sisters. And obviously the sisters' now views are known, they weren't known back then, but we can see that that is what is there. So distortion of relationships is very important, a very practical concern for restricting relevant person to those who are strictly necessary, those who require to be there to discharge responsibilities more than rights. There is also a numbers question, and I appreciate in principle reported against Kay, the court was not so concerned. Numbers is not an absolute requirement.
You're on the 4 practical reasons, aren't you,
yes,
why the reporters
yes,
object?
I will be
are you
very
moving
brief,
on? Is this number 2?
This is number 2, and I appreciate the time.
Yep.
Again, not before the court, but the UN Convention on the Rights of the Child, the General Comment 12, asks that proceedings concerning children be accessible and child appropriate. One need only look at this room to see the wisdom of that. To bring in a child, these children in XY were 12, 13 or 14 when this actually came about. And Mr. Setright, and he will have to explain this, estimates that if all of the siblings, because there are 7 siblings, so there would be 6 as relevant persons added if XY is added. If they're all added, there could be 25 people in the room. And one can look on the web in the Scottish Children Reporters Administration and see photographs of the rooms. They are not large. To bring a child into that room and expect the child to speak about intimate matters is again inhumane. And again, with taking the example of LM, to expect her in the presence of her brother to articulate reasons why she would not wish contact to take place, again would be inhumane, not child-friendly. The direction of travel on these matters these days is to keep informality to a premium, if that is possible. So accessibility and child appropriateness. And I accept that, of course, one of my compromises, Section 78, will have ABC and XY present, so we are getting up, increasing the numbers. But the point that my lady in the chair made was Section 78 was present at any one point in time. And of course, it is possible to have a session about contact, deal with that, and then move on. It's an objective that is desirable. 3, confidentiality. Subject to any creative thinking that is possible, there is no difficulty. Even my learned friend Miss Brabender accepts that ABC does not need to see information that's confidential to his parents and not directly related to confidentiality. But confidentiality, albeit I speak of it briefly, is a critical matter. It's the factor on which LM relies. And again, speaking of ordinary families, what a 16-year-old would expect is, I've said, again, speaking perhaps of my own family, a good school report, one would expect all of the children to be sat down and told about a good school report, but that's not to praise one, that's to encourage the others. A bad report unlikely to be a family meeting, more likely the offending child to be taken into a separate room and told, improve. That is what is at stake in these cases. And confidentiality in numbers. We are losing, by this expansion, the object of the exercise, the focus on the child who needs solutions to its problems. That is a concern. And finally, simply a question, who is a sibling? And indeed, what others are covered? We're in unusual cases here where we have, it would appear, full brothers and sisters living in one family unit, half-siblings, in the context of a separation of parents, siblings living in different households. Are they all to be notified? And in particular, what damage does that do if confidential information about a child is given not to loving grandparents, but what in a divorce situation one would think of in terms alternatively as ex-parents-in-law in the context of a rather bitter dispute. And of course, it's not just siblings, but other collaterals, aunts and uncles, grandparents. How many people? In concluding, and I apologise for overrunning, in concluding, in fact, as between my learned friend Miss Brabender and I, there's a very narrow distinction, because in making her 6 points that she wanted, the minimum requirements, I'm more interested in the 3 that she accepted she did not need. She didn't want obligation. Principally, she didn't need access to the papers. If one slices a salami, one is left with a salami. If one slices the rights and obligations of a relevant person, one is left with a participant, which is what ABC and XY are in terms of Section 78. And in concluding, as I've stressed to the court, this is not going to make life simpler for the Scottish Children's Reporters Administration. They have onerous responsibilities, but all public authorities these days have onerous responsibilities courtesy of the Human Rights Act to find positive, constructive solutions, not to simply run, to bring the legislation down and go to Parliament and say, give us new rules. They work constructively to find solutions for all children. They have in these cases. There is no complaint by ABC and XY that what actually happened in practice did not meet their needs, other than I accept ABC on the 7th of September, as the Inner House said, very quickly resolved in December. For these reasons, ladies and lords, unless I can assist the court, those are my submissions.
Thank you very much indeed, Mr. Moynihan. I take it your junior does not wish to follow, as junior is nowhere near us. But you're free to do so if you would like. Ms Dunlop, do you wish to start now, or do you wish us to adjourn and return at 1:55?
I would choose the latter option, if I may, my lady.
Yes. Very well. Well, we will adjourn and endeavour to be back at 1:55. Thank you.